here to launch 2 good law reports. And I'm here to introduce the speakers, but before I do that, I would like to just give a little bit of context to the Good Law Project. The Good Law reports are obviously the products of the Good Law Project. The Good Law Project is an initiative of the Free Market Foundation. It is being established as a dedicated resource for purposes of promoting and protecting key constitutional principles. The constitutional principles that I refer to are principles such as the rule of law, the separation of powers, and the supremacy. Sorry, it's still fine. And the supremacy of the Constitution. The idea behind the Good Law Project is to publish reports that would define and almost demystify some of these principles so that people understand them better and they are able to be properly implemented. Now, this is what the Good Law Project is. The question is, why this intervention? Why do we need such a thing? I think most of us, living on the African continent, would be aware that in the absence of proper safeguards, there have been what one can refer to as rather corrupt, incompetent, authoritarian, and possibly dictatorship type governments that have emerged. And the interesting thing about this is that these governments have not, these problems have not occurred because of the absence of a good constitution. They have occurred even when a good constitution was present. They have occurred because of the ease with which people in power are able to either repeal, subvert, suspend, amend, or even just brazenly ignore constitutional provisions. So a good constitution in itself, one that is ethical and provides sufficient protections for the rights of people, is not in itself a safeguard. You need something more than that. So, for example, we need the Constitutional Court. The Constitutional Court is there to ensure that the Constitution is effectively upheld. But beyond the Constitutional Court, we also need to create a culture where stakeholders, and particularly government, is able to see and regard these principles as almost sacrosanct, that they cannot be violated, that they cannot be breached. And this is going to be one of the roles of the role of the Good Law Project, is to create and foster this type of culture. At the end of the day, we need to understand that it is individuals like you and me. It is people that have the power over their realities. They have the freedom to choose what they want. And they delegate some of this power to an entity called government, okay? And they do it for a very specific purpose. They do it in the interest of the collective group and so that society can function properly. But they do it in terms of a mandate on very specific terms and conditions and subject to very specific limitations. And it is therefore not just moral and ethical, but it is an absolute requirement that when government exercises its power, it does so in terms of the people's mandate. In fact, I would go as far as to say that, the legitimacy of the exercise of power is dependent upon government observing the limitations that are set in this mandate, which is what the Constitution is. So, at this stage in our history in South Africa, we had an interesting point. We do have a very good constitution. It properly protects the rights of people and so on. We have the Constitutional Court that's there to effectively uphold the principles. But we need to create a culture in which stakeholders understand what these principles are, understand the importance of observing it, and are willing to come forward whenever there are breaches or violations. So that's just to contextualize where the Good Law Project has come from. We have two speakers who are going to speak to the two reports, which are the first two publications that have emerged from this, this new initiative. The first report is on the principles of, it's called the Principles of Good Law, and it essentially sets out the basic principles in the Constitution, the requirements of the rule of law, the requirements of the separation of powers, the requirements of ensuring that the Constitution remains supreme. The other report is essentially a set of guidelines on alternative dispute resolution, and also has its place within the rule of law principle. Our first speaker is Professor Mervyn King, and by way of introduction, there's not much I can say. His reputation certainly precedes him. Professor Mervyn King is a well-respected and well-known legal practitioner, international ADR practitioner, international arbitrator, and international guru on corporate governance. He's also been responsible for chairing both committees that produced the two reports. Professor King is going to give an overview of what these reports are, and thereafter he'll be followed by Leon Lowe, who will give more detail on what the content is in each of these reports. So on that note, I'm going to hand over to Professor Mervyn King. Thank you.
Sheena said that this was a project of the Free Market Foundation. I need to go back a bit before that, to the time when Mr. Mandela was president. And there was a Section 21 company, the old Companies Act, which is now a not-for-profit company, called the Law Review Project, which I chaired. Leon was an executive on it. And the purpose of that project was for us to remove from the statute books of South Africa objectionable legislation. In the nature of things, it was specifically directed at apartheid legislation. That, as you can imagine, took a few years. But the Law Review Project became associated with the Department of Justice. And when Penuel Maduna was the Minister of Justice, he approached the Law Review Project would we write something about what is good law and what is not good law. The reason was that he was concerned that, as you know, Parliament will pass an act, and in that act, in many of the acts passed in our Parliament, the right is given to the minister or one of the persons in that department to pass regulations. And the regulations, of course, become a law and have to be obeyed. The regulations do not go through the rigors of parliamentary debate. They don't go through the so-called public participation, which unfortunately in South Africa is more in form than in substance before policy is developed. And I think the best example of that is what has happened recently with our visa debacle. With whom were these public consultations held, and what conclusions were drawn by the minister concerned when he passed those regulations? So Penuel Maduna was concerned about that, and he asked us, the Law Review Project, to try and lay down some guidelines for people who were drafting these regulations, none of whom was a skilled draftsman. And the consequence was that regulations were appearing which were ambiguous, some actually not in line with our Constitution, the rights under the Constitution. And arising out of that, we called it the Good Law Project. So it fell under the auspices of the Law Review Project, and the Good Law Project was under the Law Review Project. We worked on it, and Minister Majuna actually asked us, would we investigate what was happening internationally? Because Leon Lowe, your next speaker, had actually visited 8 different countries and gleaned from them what happened in those countries. All those countries had some form of agency to assess the cost-benefit of a regulation or a law, be it primary legislation or subordinate legislation. There was, in some countries, there had to be an impact assessment before any regulation was passed. In Norway, they went as far as to say, the test is regulate or not to regulate. In Australia, what is the mischief that you're trying to eradicate or ameliorate? Is the tool which you have chosen the correct tool? How are you going to enforce it? If you cannot enforce it, then it falls into disrepute by disuse. The UK has an assessment tool, an agency to assess the impact of the regulation on financial, social, and environmental issues. We have public participation before policy is passed. In Leon's investigations, and Advocate Ashina Singh, she's very modest, but she is a lawyer of some distinction, and she and Leon have been the real, can I describe you as a workhorses, on this. And yes, I chaired the project. And it was a privilege for me to do so. But we came to the conclusion, and the late Michael O'Dowd of Anglo-American, you will remember, he was a participant in all this. We came to the conclusion that we should write down guidelines for these draftsmen in the various departments that are drafting regulations. But I found it interesting, the Minister of Education, who's been in the news somewhat lately, with what's been happening at our universities, has proposed a bill called the Higher Education Amendment Act. Now, those of us involved with universities, I chaired the Board of Governors at Wits University for 14 years. I know how universities operate. Our council and governors' meetings used to take 2 to 3 hours. Today, some of them are taking 2 days. Well-intended legislation, but with adverse consequences. Everybody involved in the administration of a university has to be represented on the council. Labour Union, Students' Representative Council, outsourced workers, junior lecturers, senior lecturers, deans. So a potpourri of thinking. In the amendment bill, and that's why I've got it here to read it to you, because it illustrates, and this is primary legislation that's going to go through Parliament. In the amendment bill, the Minister says he wants the power to determine the transformation goals of any academic institution in South Africa. Not defined. To intervene in various ways, including through directives for failing to fulfill functions effectively. Effectively, according to whom? What is the measurement? Appointing an independent assessor in the best interests of an institution. Who determines those best interests? The Minister, who's giving the direction? Appointing an administrator if an institution has not complied with the directive to the Minister's satisfaction. And to establish this is a very interesting word, and to disestablish an institution if the Minister feels its functions could be provided effectively and efficiently elsewhere. Note, not more efficiently or more effectively and more cost efficiently elsewhere. So, the importance of the Good Law Project, number one, as I call it, to give guidelines to these draftsmen in the various departments, particularly in the subordinate legislation, is something quite critical. The intention was for it to be launched by the Department of Justice. Peniel Mbaduna was no longer Minister of Justice. Mr. Radibi became Minister of Justice. And Leon and I did endeavour to get him to launch this, but I don't want to say we were fobbed off, but certainly we didn't achieve our purpose. And that's where really the private sector took over, the Free Market Foundation. Because by that time, we, in the Good Law Project, had come to the conclusion this was critical to get this into the understanding of particularly these people involved in creating subordinate legislation. So, Leon will talk to you in some detail about our recommendations. Obviously, that any primary legislation or subordinate has to be in line with the constitutional requirements. But we've recommended it has to be feasible in the sense of what are the foreseeable and unintended consequences of these regulations? What is the impact environmentally, socially, and financially? What, in other words, is the cost-benefit analysis? What is the cost in budgetary terms of implementing and enforcing this? Does the department concerned actually have the skills and capacity to enforce this? Otherwise, it falls into disuse and, of course, becomes useless. Then the drafting has to be clear, concise, and understandable, and there's got to be recognition of existing law. Just accept from me, for the moment, that regulations are being drawn, which is a duplication of a regulation in another department, for example. In some cases, there's not a proper delineation of functions between the regulations of one department and another. So we have followed what's happened in 8 other countries and recommended generally that there should be independent agencies in South Africa to screen proposed laws, both primary and subordinate, to do impact assessments and a review of existing laws so there's not a duplication. We also have a checklist to ask the question, what mischief is the law trying to eradicate? What is the cost benefit of it? Who is going to enforce it? And what are the consequences, foreseeable and unforeseeable? Power has been given to so-called ombudsmen, tribunals, and commissioners to adjudicate. Section 33 of the Constitution's foundational value is the rule of law, as Sheena has already pointed out. The object of the rule of law is to prevent the rule of man, to have certainty. We need certainty in our lives. Business, in making business judgment calls, certainly needs certainty. The law creates certainty. The rule of man could be at a whim. What I think is right, you may not think is right. We don't have precedent when these adjudicators don't follow substantive law or fair legal procedures. It was interesting that in 1920, in our Cape Supreme Court, as it then was, now High Court, the court pointed out that any arbitrator has to make sure that no evidence may be given or produced before him in the absence of any one of the parties. Now, I have to tell all of you that there are adjudicators who are doing exactly that almost on a daily basis in South Africa. And that's contrary to the Constitution, to Section 33 of the Constitution. It's even been held by our courts that parties, disputants, to a dispute that's going to come before an adjudicator cannot agree that the adjudicator can abandon the principles of natural justice. Each party can be heard. Each party is entitled to produce evidence. Each party is entitled to make submissions. So we have done guidelines, that's the second report, on the basic principles of dispute resolution. It became necessary because of what I've said to you, that disputes are being adjudicated between what the regulator wants and those who are being regulated. But I think more alarming is the fact that what the regulator might have intended is not on a structured and proper construction of what is written, should be carried out by those who are being regulated. So there is a huge gap between the regulator and those who are being regulated. So in short, and Leon will adumbrate this, I'm sure, in the second part of the Good Law Project, we point out that any adjudicator, in terms of the Constitution, in terms of our common law, has to apply the principles of natural justice and ensure that there's fair process in the adjudication. I just want to record my thanks and appreciation to those who've given so much input to these two projects. There are many eminent lawyers in our country who've given their time. The South African Law Reform Commission, the Commission for Conciliation, Mediation and Arbitration, the CCMA, the Arbitration Foundation of Southern Africa. I want to thank Leon and Ashina for all their hard work, Advocate Piet Lowe, who really contributed a lot, the Applied Legal Studies, the Department of Justice also participated, the Faculty of Law at Wits University, the Nelson Mandela Foundation, and Dennis Jooster, the short-term ombudsman, and of course, not to overlook the financial assistance we have received from the country council in the two reports. So, I just want to conclude by saying this. I am alarmed that there's no member of the media present tonight. Am I right or wrong? I think you will agree that what I've broadly outlined to you is a matter of some importance to every citizen in South Africa. And I will take this up with the press. Thank you very much for listening.
It's an honor and a pleasure, I might say, to follow a giant like Mervyn. And I'm going to do some of the drilling down into what this is all about. And I want to start with one example of where the rule of law is completely absent. And people think that I'm against this particular organization. I'm not at all. I'm for it operating according to the rule of law. And that will describe what the rule of law really is. We have sitting in the audience here somebody in the legal profession with whom I work, Tebogo Siapi. I'm sure he doesn't mind me mentioning him. But he came to work with us on this project some time ago and basically asked if he could get anything to read on the rule of law. And I thought that was interesting because he'd got his law degree at Wits. One assumed that he knew what the rule of law was. It turned out that he had not, in getting his degree, had as much as one lecture on the rule of law, not read one page in any book on the rule of law. And as far as I can establish, we have a professor also of insurance law, Robert Vivian, with us. There is not even anymore a course or lecture on what the rule of law is. When I studied law, there was something called the philosophy of law or jurisprudence, which was a course you would do and learn about it. And if you're older, if you've got grey hair and you've been around a while and you studied law, you will know that you learnt about the rule of law. You learnt what it is. Now, unfortunately, anyone younger than probably something like 65 or 60 has never so much as heard a lecture on it, probably not read a word. And the word rule of law floats around in the cosmos. Everyone's for it and it's a good idea. But very few people, including professors of law, could, if you say to them, what exactly does it mean, could tell you. Do the street trading bylaws of Johannesburg comply with the rule of law, yes or no? They wouldn't be able to tell you. And there is an organization in South Africa called the Financial Services Board. I'm going to start at the big end, financial services. And then I'm going to end up with the Johannesburg street traders at the other end of the economic spectrum. The Financial Services Board, if there is anyone in this room who can name one member of that board, I will be extremely surprised. It is an autonomous agency which is answerable to nobody. No minister, not to parliament, not to any department. And it's a mysterious group of people that no one knows who they are, who meet in smoke-free rooms and make laws. Under the laws that govern them, they can basically make any law governing financial services. That's the biggest and most important sector of the economy, the insurance companies, the banks, brokers, intermediaries, agents, credit providers. And they may make whatever law they wish more powerfully than Parliament. What Professor King has mentioned is that for Parliament to make a law, it has to follow elaborate procedures prescribed in the Constitution. For example, Section 195, which is mentioned about public participation and consultation. There have to be various readings in Parliament, 2 houses of Parliament, portfolio committees, and so on. Public participation and lots of media coverage. However, when the Financial Services Board makes a law, and basically all of the lawmaking function has been delegated to it by Parliament, in other words, Parliament is now redundant as far as financial law is concerned, that it has none of this. It simply makes a law. Now, you might think that's a problem from the rule of law, from democracy, from the separation of powers, which is a requirement of our Constitution. But it doesn't stop there. It can make whatever law it wishes. It implements the law. It's the administrative agency, so it's the legislative and administrative and executive. It polices the law, so it's the police and the prosecuting authority because it prosecutes the law. It hears the proceedings in its own ombuds or ombudsman courts, in these quasi-courts as they are often officially called, and I call them kangaroo courts. So the adjudication is no longer even in the judiciary. It imposes fines called penalties. It keeps the fines and spends them on itself. So here you have what Professor Vivian has coined the lovely phrase, a state within a state. An agency, a mysterious, secret, unknown, invisible agency that makes whatever law it wishes, enforces, polices, adjudicates disputes, imposes fines and keeps the money. Now, the government can't do that. Parliament can't do that. Ministers can't do that. The cabinet can't do that. And yet this has happened under our watch. Now, nobody's particularly guilty. It's not as if some nasty person somewhere was trying to destroy the country. What in fact happened was simply that nobody really understood what was happening step by step. As each little step along the way was taken, there was nobody around to say, but hold on a sec, doesn't that violate the principle of objective criteria? These are subjective, right? Well, that's wrong. The law requires objective criteria. Separation of powers. Adjudication in open, transparent courts. What about the right of appeal to an independent tribunal or court as prescribed in the Constitution? Nobody blew the whistle. Nobody asked the question. Nobody said something's going wrong here. So that by the time we wake up, it's all happened. Now, how you wind that back and how you undo it and how you bundle it, that's what the Good Law Project will set about trying to achieve for South Africa. It's trying to get us back to the lofty values and principles spelt out, articulated, required by our Constitution, and not taught to people like Tebogo sitting over there and others who've studied law recently. I see some in the room. Then I want to go to the Johannesburg street traders. Some of you might recall, now we're talking about the big banks here, but let's go to the other end of the world, the informal traders. Some of you might recall that in December 2013, the Johannesburg City Council ruled that 6,000 street traders, I forget the number, forgive me if I get it wrong, had to leave the streets of Johannesburg. The Metro Police were called out. A private sort of outsourced army called the Red Ants were sent into motion. Their goods were confiscated. They were driven off the streets. And these were often single, unwed mothers, impoverished, and Christmas coming, and did not know how they were going to give their children the next meal. We were instrumental to bringing a constitutional court case. It was precedent setting. It was the first time the Constitutional Court heard a matter immediately, didn't have to go via the high courts, a summary hearing, and a unanimous ruling that the City Council had acted unconstitutionally. It had to lead them all back onto the streets. I'm now working with the law firm Hogan Lovells, who are represented here, and also a marvelous resource and support group for us, pro bono, who are thinking about how we go and lay contempt of court charges against the Johannesburg City Council for ignoring the Constitutional Court, because it has carried on as if that ruling was never made. It is still doing the same thing as if there was no Constitutional Court ruling. And so this is how bad it is. The court makes an order and they just ignore it. Another one was we were instrumental to getting a ruling against the asset forfeiture unit for seizing assets without constitutional checks and balances. It too has simply carried on as if the Constitutional Court never ruled against it. So we have really very, very serious problems facing us in South Africa. And again, I say it's not as if there's some nasty, guilty person somewhere, some nefarious third force or anything. It is just a lack of understanding. I'm sure no one in the Johannesburg City Council or the Metro Police or the Asset Forfeiture Unit or and I've mentioned 3 examples, the Financial Service Authority, thought at any time they were deliberately ignoring the Constitution or breaking the law. Everyone acted in good faith and innocence. What was lacking is what Professor King called the culture, the mindset, a general understanding of these measures. So the Good Law Project report spells out what the principles are, objective criteria, separation of powers, where they are in the Constitution, the right to being heard, disputes being resolved in a court or similar tribunal, something that functions like a court. And then also the whole idea of impact assessments. Now, this has come a long way. We, I think, can take some credit for having introduced the idea to South Africa, then called regulatory impact assessments, which is the term used in the UK, but nowhere else. It has other names in other places, like management and budget assessments in America and so on. And what happened is the DTI, the Department of Trade and Industry, commissioned us to help them introduce these within the DTI about 10 years ago. Then we were asked to stop because the idea was taken over by the Treasury, the Department of Finance. And then they stopped their work on it because it was taken over. The Cabinet ruled that there needs to be what is now called a socio-economic impact assessment, which would cover constitutionality, costs and benefits, mischief principle, and so on, ruled that this should actually be undertaken not by a department but by the presidency. And the presidency did a thorough amount of work on it, including studying our documents, and has now published a set of its guidelines very similar to what we have produced, but with some quite serious flaws. For example, saying that it must be undertaken by the department proposing the measure. That would obviously be fatal. It has to be undertaken by an autonomous separate agency, as it is in other countries, and that's the work we did. As Professor King mentioned my travel around the world. Then the final thing was 2 weeks ago in the midterm budget, the Minister of Finance, Lanhla Nene, announced that the government had decided to finally introduce socio-economic impact assessments. He actually said that it had already done so. I was in Parliament yesterday with Themba Nolachungu giving evidence on the financial sector regulation bill, for which there is no socio-economic impact assessment, and it is the staff of the minister who said it's required. Now, how do we explain that? That his own staff simply ignore him. And does he realize that they're proceeding with a measure without taking what he requires as a precondition for the law? So this is one of the sorts of concerns we have. And again, I want to stress that everyone, I think, is in good faith. They just don't know. And so our job, and the purpose of this job, is to make sure that everyone who should know does know, that they have clear, simple, readable, objective guidelines that everybody can follow and tick what's right and wrong. And when a law is proposed that violates one of the principles of good law, and I haven't specified them all, it's a long list of about 25 criteria, starting with separation of powers, objective criteria, and things like, right to be heard and some of the things Professor King mentioned, that everyone will know when they see something wrong, they will automatically recognize it as wrong. And we won't have all these mistakes made by mistake. We had, for example, you mentioned Dennis Jooste, who's been a great help to us, an eminent retired South African legal practitioner who took over the short-term insurance ombudsman office. And he took over from somebody who didn't seem to understand. I'm not going to name anybody, but with whom we had some difficulty. And he was fabulous. He was amazing. He just immediately implemented these guidelines, understood them properly, and has turned at least one ombudsman office into something like the South African Arbitration Foundation, AFSA. And the CCMA is amongst the good examples of where alternative dispute resolution is done properly and according to the rule of law and principles of natural justice. And so there are some good signs, some good developments. There is another ombudsman office who I think is represented here today, who seems to me to be headed in the same good direction of sorting out, and I don't have permission to name them, and I'm sure he knows what I'm talking about, so I won't. But so there are good developments, and there are very, very good people out there, and I think a lot of good people just don't know. So this is an exercise in public education, information, principles. So what will this do, and I'll close off with this, the project, the Good Law Project, will disseminate the information. It is going to start off being on Kindle and Amazon. The print versions will be available early next year, but it's orderable. All of you should have a copy of this on your seat. And there is with it also a form for you to make contributions to this extraordinary project. If you know anything more important for South Africa, let me know. It's hard for me to think of anything that could be more important than this. We do have another project to do with land titling, which I think is between the two, there's some contest. Which is the more important thing to do in South Africa? Make sure everyone who has a piece of land owns it, or to make sure we have the rule of law. Probably the rule of law is the more fundamental and profound, and a proper dispute resolution. So you can support it. So we will disseminate the information. The idea is to make endless submissions whenever bad measures are proposed or thought of, as we did, for example, on the proposed liquor regulations. They just, every single word there was a violation of the most elementary concepts of the rule of law, and we had very long meetings with the DTI, who I think accepted that they just had got it wrong, and we're waiting now for an amendment to that. And we will maybe bring cases. I'm not sure about that myself. We have an unresolved discussion internally. My own personal inclination is that it shouldn't be a litigating organization, but should rather just be helping everybody. It's a support structure and organization. And litigation should be done through some other channels where the principles of law are violated. And then run courses, literally training and education courses, so people who've studied law and never had a lecture on the rule of law can come and learn about it. We can have short and long courses. And I think every government law advisor and everyone tasked with drafting legislation should not be able to do so without going on a course. In my travels around the world, and I'm talking not only of first world countries, Nigeria, Ghana, Kenya, and first world countries, America, France, Germany, Norway, New Zealand, Australia, and others, What was interesting is that legal drafting was regarded as a special branch of law. Something like, say, brain surgery is in medicine. What we have now is we have brain surgery being done by GPs, by general practitioners, essentially. We do not have anyone in South Africa who's taught legal drafting. There are no courses in university on how to draft and write laws and what are the principles and criteria for law being a good law. So we want that. We want to teach and train people so they understand these principles and can implement them. So it'll be submissions, dissemination, and courses and training and information, and a resource support group for anyone who wants it, and maybe actually here and there bringing a challenge where something has really gone off the rails. So I'm very excited, I really am, and as I say that, I do get goose flesh. If I can go to the grave one day and feel that Professor King and Sheena and I and others in this room, Dr. Benfield and Professor Vivian and others who've worked on this, and the law firms concerned, Bieldermans, Hogan Lovells, senior counsel in South Africa, Gilbert Marcus, David Untalter, Martin Brassey, and others, Pitt Lowe, have helped us, and then I will consider my contribution to society has been pretty worthwhile. And the absence of the media here is perhaps because it's too new, perhaps because it's too important, perhaps because it's too shocking, I don't know. But this is your chance to be part of the birth of a very, very potentially promising baby. And I really want to say thank you to Professor King for being a mentor and at times I have to say a tormentor. Thank you.